The Insolvency and Bankruptcy Code was seen as a game changer for the creditor-borrower relationship and promised a window of hope for the banking system that was being crippled by mounting non-performing assets and defaults. But 2 years since its inception, the code's report card paints a grim picture. According to the Insolvency and Bankruptcy Board of India, close to 1,200 corporates have gone in for insolvency resolution at the end of September 2018. Of these, 118 have been closed on appeal or review, 52 have yielded resolution, while 212 have resulted in liquidation. The 12 large defaulters identified by the Reserve Bank in June of 2017 and an additional 28 later that year together account for almost half of the banking sector's debt, which stands at around 10 lakh crore rupees. Together, these 40 defaulters owed Indian banks over 5.2 lakh crore rupees. But from that first list of 12 defaulters, only 5 have been closed in one way or another. While Electro Steel Steels has been sold to Vedanta Group, Tata Steels has bagged Bhushan Steel, and a consortium of Aeon and JSW Steel has bagged Monetis Part. Lanco Infra is headed to liquidation. But in the case of Jyoti Structures, the NCLAT has asked the highest bidder to revise their offer so that liquidation may be avoided. Liberty House was identified as the winning bidder for Amtech Auto, but failed to pay lenders within the stipulated time. The case of Bhushan Power, where JSW Steel was declared the highest bidder, is now caught up in a bitter courtroom battle. Rival bidder Tata Steel has challenged the NCLT's decision to allow JSW to revise its bids after Tata Steel was declared the highest bidder. Another courtroom battle involves SR Steel. Here, SR Steel's promoters, the Ruya family, made a last-minute offer to repay lenders and withdraw the company from insolvency proceedings. This offer came over a year after the company was hauled before the National Company Law Tribunal, and subsequent proceedings deemed ArcelorMittal to be the highest bidder for its assets. In the case of JP Infratech, the clock has been set back by a year. This after the top court ordered the home buyers would get a seat at the table with other creditors, and so insolvency process would have to start from scratch. ABG Shipyard has also not had a smooth sailing. Its lenders recently rejected the resolution plan submitted by sole bidder Liberty House and may soon file to liquidate the company. In case of Alok Industries, the NCLAT has upheld the NCLT's order directing the resolution professional to reconsider the bids submitted by JM Financial and Reliance Industries. For ERA Infra, the resolution process has barely started. Interestingly, the recent orders handed down by the Supreme Court have only lent an air of uncertainty to the process. Confronted with the question of whether the sanctity of deadlines and the process could trump ensuring high returns to creditors, the Apex Court ruled that value maximization should be the guiding principle. This has raised questions as to whether resolution applicants who lose in the bidding process can come in through the back door with a fresh offer. As the IBC enters its third year, a more important question looms. Could the IBC itself not have a long time to live? That's because over 40 petitions have been filed that seek a scrapping of the IBC, citing various issues. Arguably, the most pressing issue is the allegedly discriminatory treatment the court metes out to operational creditors. For example, the Committee of Creditors, or COC, currently consists of only financial creditors. If the Supreme Court directs equal treatment of operational creditors, it would turn the clock back on all pending cases. Here are also a few petitions that challenge the very appointment and composition of the NCLT as well as the NCLAT. The court's decision on this point could spell trouble for the IBC regime itself. All this means that the wait for a smooth IBC could well be a long one, and legal drama will keep 2019 quite interesting.